Maria Bottis is a professor in Corfu and a long-time friend of Nexa. She came 3 years ago, I think.
I believe it's only 3 years.
On invitation by Ugo Pagallo, I
Yes.
think, who is in London. So that's why he's not here to pay homage to Maria. And she spoke to us about an issue, notice, which is the right to oblivion. And this was well before the March 2014 case by the European Court of Justice. So she was talking to us about the subject, which at the time was not so in the headlines as it has become in the meantime. I must say that I listened with attention to what she said. I don't know yet what is the right solution. It's a very difficult subject. Today she's going to talk to us about another subject, which is a decision by the European Court of Justice in the Ionian case. But before she does this, I will go around the table and say who is present. I just presented Professor Bottis. So we are going around the table to make presentations of the people around the table. We start with Cristiana, I think.
Hi everyone, I'm Cristiana Sappa. I'm researching in intellectual property and I'm teaching intellectual property at Alexandria Law School.
Good.
Federico Marando, I'm the Director of Research here at the Nexa Center. One of my main topic of research is open data.
My name is Giuseppe Rutia and I'm the Communication Manager here at the Nexa Center.
I'm Alessandro Menante, I'm the student and I'm part of the Nexa Center.
I'm Antonio Cagliotti and I'm studying law at the University of Turin.
He's graduating with me with a dissertation on the right of communication to the public. And particularly about the space shifting phenomenon. We are not sure exactly about the boundaries of his dissertation, but maybe we'll find something today.
Raimondo Iemma, Nexa Center, #OpenData.
Hi, I'm Bianca. I'm also studying law and I'm working in my thesis on technological protection measures.
Good evening, I'm Alberto Scella. I'm an in-house lawyer in an insurance company here in Turin. Sorry, to give us some precious advice on data protection, and we currently invited today to attend this conference.
So we have a mix, and Marco recalls you, we have not many people, but very selected people around the table.
It's a very great honor to be with you. Thank you for inviting me for a second time. First time was about proprietary oblivion, and we did not have yet the decision of the court, which anyway, I think...
But yeah, we more or less divide, we speak as much as you like, but not beyond 55 minutes, and then discussion. Okay.
Don't be that much. No, don't be afraid.
Oh, this is the follow-up.
Yeah. So today, we're going to talk about a case. I'll start with a few basic stuff that perhaps everybody knows, but I felt it was necessary to include in this speech because sometimes we forget the basic stuff. So what is open data? Open data is freely available to everyone to use and we publish as a wish, so we don't have copyright or patent or trademarks on open data. So what is not open data is a space, let's say, which is covered by copyright, patent, and trademarks. There's no use in doing this. You know the definitions. So what's not open data is a space which is covered, it's enclosed. We have some dichotomies in intellectual property. Everybody, I guess, knows them. Idea expression, author, original work of the mind, or we have a collection of facts, which is a different thing. We have the terms author, and we have the term maker of a database, which is in the database directive. And also we have in patent law the division of invention and of discovery. So there's a free space which is data in the public domain. So facts, ideas, works whose copyright has expired, no rights. There's a space, fair use to work or exceptions and limitations. This could be some commentator could also this into the public domain. And we'll have trademark disuse, the failure to assert trademark rights, in common uses by the public without regard to its intended use. All these fall into the public domain. We call these open data. Value of free space, public domain, open data. I'm not going to go through this. I think everybody knows, people who say yes, open data, understand what we mean. And in this particular Ionian case, open data is more related to free competition, which is another thing. It's not about knowledge, access to cultural heritage, or promoting education, or we have to have free open data, like with Ryanair listings of flights, because we want, first of all, we want to have free competition. So, we have two classes of domain. One is the enclosed domain, copyright, patent, trademark, and the other one, which is open, free, public data, and public domain. Like Benkler, who is related to the Nexus Center, because from Berkman Center from Harvard, he called his free as the heir to common use. So my question which arose immediately after the case, which I'm going to describe in a minute, is there a third space? Is there a third domain, a quasi-public, a quasi-enclosed space, a third space? We have a long literature about commodification of information, which presses the public domain very much. We have some items of information we used not to have no economic value in the past, but now they do have independent economic value. Factual data, facts, personal data, genetic information, and pure ideas. If we take all of this and we commodify them, and in a way we try to sell them, then we're taking parts of the public domain and into the enclosed domain. In this commodification of information is taking place through intellectual property law and contract law. So let's talk about collections of information. Copyright doctrine was always in trouble with collections. In the old days, we had collection of poems, we had flower collections, encyclopedia, guides, lexicons, collections of laws, judgments, and telephones. This was the collection of information we didn't know how or if we should protect at all. In the US, in a landmark decision, perhaps most of you here know, but I reminded, the Feast decision in 1991, the Supreme Court rejected the sweat of the brow doctrine and said that copyright protects originality, not effort. This is a phrase to remember. So there's no protection, they said, to telephone lists. These are free to copy forever. This is a public domain. This is open data. And this instigated pressure for legislation upon the US, both the US and the EU, this decision. In 1996, we had this so-called sexy directive. I found this in the commentary of this case, right? And it is
sexy directive.
Yeah, it's not my word. It's not my word. I found it in a commentary, but perhaps it has led to so much different views and pros and cons that it could be supported. So in the beginning, before we reached this directive, all the discussions in the European Union were about an unfair competition model of databases, which means give some extra protection when a database is being wholly stolen, let's say, and published by a competitor, or a competitor who became a competitor. And in the end, all this was turned around, and we have a very tight copyright regime, an absolute right in them. So, a database is under the directive a collection of independent works, data, or other materials arranged in a systematic or methodical way and individually accessible by electronic or other means. So this is so very, very wide because it says a collection about everything. What's important to note here is that the purpose of the database, whether the database is an information work to be sold as an information work or not, that's not relevant. So we have a new sui generis right, which is a right for the maker. We don't have an author because it's not original work. We have a right for the maker of the database to prevent extraction and or reutilization of the whole of a substantial part of the contents. So you cannot take a big part of a database and reproduce it, to put it in a very simple way. And then you protect the maker, which is a very new word in the intellectual property regime, a very new word. That's one part of this exercise. And what you need is investment. If you can prove that you invested, then that's it. The purpose of the new right, from the recitals and other sources, we had economic justifications. What they wanted is to foster a strong European database industry, to sell more databases, to produce more databases, sell more databases. Because they thought that strong IP rights like this means more database protection. And to surpass, if possible, the American database industry. This is in text. You can see it in the comments. This didn't happen. So the investment, if you can prove investment, then you have protection. So we're not talking about originality. You don't have to be original in your expression, but you have to prove that you spend a lot of money, or that you use specialized personnel, or this is the line of thought. And the right means that you have the exclusive right to control extraction and replication of a substantial part of the database. You have exceptions. This is a very important part, but these are only for the lawful user. Again, a new term, very new term in the intellectual property regime. Who is this? A user who's already bound, for example, by contract, because they contracted to use the database, or perhaps a user who invokes an exception, and this would have a question mark here. And another question mark is where we have a user invoking in fair dealing. But what's important to remember is that the exceptions have to apply for the lawful user, and they do exist. They do exist, some exceptions. For private use, it's optional. For a lawful user may extract or really utilize insubstantial parts of the database, and this may not be altered by contract. This is the important thing to remember, that the maker of the database cannot contract you out of this right you have to take small parts of the database.
This is in bold because this will be in the decision.
Yes,
that
exactly.
There is no contracting out that will be.
Exactly, that's why I have to do. And again, you have the usual rules that you can't do anything that would conflict with the normal exploitation of the database or would unreasonably prejudice the legitimate interest of the maker. We've seen these sort of restrictions here. And again, repeated and systematic extraction, even on small parts, is not permitted. It's an abuse of the rights, so they won't let you do that. Now, what's the nature of this sui generis right? It's a strong property right. It's an exclusive right. It lasts 15 years, but if you update your database all the time, then it never ends. It's perpetual protection. This is one of the main objections of people. You gave for the first time intellectual property, let's say, to data, that they never end. They're stronger than anything else. And they're covering collection of facts, which ordinarily merit no intellectual property protection. This is another of the objections we've read extensively in the literature. How was the directive implemented? I won't go through this. Very, very, very differently. Okay, every country did whatever they wanted to do, and we totally failed the main objective, let's say, of the directive to harmonize the protection for databases. This never happened. Evaluating the directive, what did the court say? We had some litigation, let's say, in the European courts, mostly on what were called, I think this is Hugenholz's phrase, synthetic data. Telephone numbers, days, place, like data that you make, not real data. A database in courts is everything. We have cases about movie schedules, news articles and headlines, job records, a collection of 251 web links, a hit charge, advertisements, addresses. This is a very sad list, according to a well-known article of James Boyle, who perhaps you know. So the sad list, he says, goes on. But 4 cases issued were jumbled together and remanded to the European Court of Justice for clarification, the William Hill cases. This was about let's say, horse races, and British Horse Racing Board, which is very important in the UK. They didn't want to leave the William Hill Corporation to use their database without paying, because it was money. I think it was about money. I will license you this, that you cannot take my horse races and the races without paying. And what was the result? It was a very good result, I think, and that's what they call domesticating the sui generis right. because the court very rightly said that the substantial investment to the construction of this database about horses and jockeys and when is these races, they were not investment in obtaining the data. You would have this database, they said, anyway, you would construct it because you want it for another purpose. So this database is a spin-off. And the purpose of the database just became important because it should have been directive anyway, I think. So they didn't protect this database and they rejected the claims. Makes perfect sense to me. But it did not resolve all the interpretation problems with that, I think.
Yeah, just let me summarize for my students. You speak in English, I say it very briefly in Italian. L'idea è che se la banca dati non è fatta per avere quei dati, ma perché facendo altro, ad esempio l'attività di pubblicizzare le corse dei cavalli, tu metti dove si trova, che chi vince, non hai un investimento per creare il database, è un incidente necessario di un'altra attività. Ma la protezione del database si ha soltanto quando l'investimento è specifico per avere una raccolta di dati. Questo era invece un incidente di un'altra attività, quindi niente protezione. Questo è importante.
Okay, thank you so much. Thank you so much. So, did this court resolve the interpretation problems with this case? No, because we have a lot of problems with the directive. So, for example, how can you make the difference between created data and obtained data? That's not also always easy. If you record meteorological data, do you create them or you just put them down? Do you record them? So these are sort of metaphysical distinctions that we don't know how to resolve. Then, evaluating the directive, not by the course. We had an evaluation by the European Commission itself, and I mention this because it's very important. What they found out is that the economic impact of the sui generis right is unproven. We've had 1 to 2 ratio EU-US database in 1996 and 1 to 3 in 2004 when we have the directive. This is an example of a failure when we imposed a restriction, a new restrictive rule in the intellectual property area, and then the result was not to have more databases. So this, from the economic point of view, it was a big failure.
Maria, let me interrupt you. Apologies once more. The United States does not have database protection, but nevertheless they have more value in databases than Europe, which has the protection.
They are number one. They are fantastic. They're very good, and they don't have any rule about protecting databases. Exactly.
Yeah.
That is the problem because of the fees decision that we mentioned in the Supreme Court.
Because of the fees.
Yes, because of the fees decision. So, is this a death of a directive or the evaluation? It was a kind of a death, let's say, because the plans to introduce similar legislation in the States have freezed. For example, the United States decided we're not going to enact any sort of law of this kind because we don't need it. Plans for an international treaty also froze, and independent states considering similar legislation also stopped. Everything stopped, apart from the European Union, of course, because we had already the directive in the first place and we didn't repeal it, of course. So the proposals in the evaluation was to ban it, repeal it, stop it. It's not a good idea. Withdraw the sui generis right, keep the rest, the protection of original databases, but stop the sui generis right, amend it, or maintain the status quo. And they said we can stay as we are because it's very difficult to confess that you've been such a great failure by enacting a directive that's such a big failure. So, and the next case is the football dataco case in 2012, which it domesticated the right even more. They said if you want protection because you have an original database, how can you have an original database? In the structure, how you make it, and in its presentation. Because if you have a collection of facts in the public domain, but you can have a nice original structure and nice original presentation, And then you have an original database. But you need to show this originality if you want the protection. And this is difficult to show. So the court again restricted the area where this database right could exist.
Football fixtures are il calendario del campionato, cioè hanno detto il calendario del campionato sarà utilissimo, ma certo non è anche difficile farlo, perché bisogna combinare tutte quelle squadre, quelle date, ma non è originale, quindi non ha la protezione del diritto d'autore, che è il secondo livello di protezione.
And somehow we come in Ryanair. It's 2015. And before that, I was pretty happy because I have written a book on the illegal protection of databases in 2004 and some articles afterwards. And I thought we had come at least to a good solution of restricting the sui generis right to a particular level. Now, Ryanair was decided without an opinion of the Attorney General, which is, this is original. Usually we have an opinion of the Attorney General. But even if it was just one little question, they took 1 year from the application to the decisions they issued. The facts are this. PA Aviation took data from Ryanair for price comparison and sold tickets. If you want to buy a ticket to fly or wherever, you would like to have a price comparison. Say to go to Corfu, for example, where you should come. The easiest and cheapest way is actually Ryanair, because you can find it for 24 euros. But anyway, you like to see all the comparison. And that's what PI Aviation did with Inheronsa. He scraped with tools, of course. And they compared, and they also sold tickets of Ryanair. Aviation sold tickets of Ryanair. Ryanair didn't like that at all. Ryanair, as a company, is very aggressive in protecting whatever exists there to protect. They have been in courts very, very many times. Sometimes they lose, sometimes they win, but they're generally very, very aggressive. In this site, Ryanair has general terms and conditions, as you have seen in many sites, I guess, how to use this site, who owns this data, and all that. And in the general terms and conditions, Ryanair is very clear that you cannot use the site for commercial purpose. Meaning that you cannot sell tickets. You're not going to sell my tickets. Okay? You will not use the site unless you tick, and then you have a contract, and you will not sell tickets. PRA didn't do that, so Ryanair sued. In the national courts of the Netherlands, Ryanair lost in the first court and lost again in the Court of Appeals. Ryanair said what any lawyer, I guess, would say in this case. This, even if there are conflicting arguments, that my database is original. Two, my database is not original. So I have a sui generis right. And three, anyway, you are in breach of contract. You broke a contract you have with me. But the first court said, no, you're not right, because they based it on intellectual property law like copyright. Aviation has an exception to use. They can use this exception and use your database. And the Court of Appeals said Ryanair is not right at all and lost on all grounds. You don't have an original database and you don't have a non-original database, so you don't have a sui generis right, and also breach of contract. They are not in breach of contract, so they lost it. The Supreme Court asked the Court of the European Union, can this contract be valid if this database is not original under the directive and it's not non-original under the directive? So no sui generis right. Can I have a contract? This is it's an option. So I think the question was, when is a database under the directive? And the court said yes. You can use the contract. The database, let's say, owner, I put in brackets because you cannot not own data, is not bound by the directive's exceptions to the exclusive right, because the whole directive is inapplicable. If you have a database like this one, they said, which is pure facts, it's a collection of facts, and you didn't have any substantial investment to creating this data, then the directive doesn't apply. And then the procedure said, so we have a stronger protection for this database. Because you can use contract, another legal basis. Even if this database, you can't prove anything like creative effort into making it, or substantial investment. So what would you do if you were Ryanair? The first thing you'd say is that, no, we're not original. No, this is nothing. This is not original at all. And we didn't spend any money on this. No, nothing. It's a silly thing. So give me contract, which will take me where I want to go. Because in contract, in theory, I say theory because this is also regulated, you can put any terms and conditions that you want, because it's supposedly freedom of contracting.
Here again, a very short summary in Italian. The point is that contractual restrictions are invalid if they relate to an original that I thought I was speaking in Italian. Scusate. Le restrizioni contrattuali sono nulle se si applicano a una banca dati tutelata dal diritto d'autore oppure tutelata come sui generis. Però, se quella non è tutelata dal diritto d'autore come diritto sui generis, non si applica neanche il divieto delle restrizioni contrattuali. E allora le restrizioni contrattuali paradossalmente diventano vincolanti per l'utente nei casi in cui la banca dati ha minore valore perché l'ordinamento non la tutela, che sembra un po' essere un controsenso, come credo che la professoressa stia per dirci. Antonio.
Però tutto questo ha senso.
Antonio, prova a dirlo in inglese.
You can't ignore the exceptions, the contractual clauses, if you can use the exceptions from the directives. Section 6 and
15. Yeah, 6, 8, and 15 together.
Yes.
What's the question?
That can you ignore the contractual clauses only if there are these exceptions?
Yeah, but the court says that you don't have you cannot rely on the exceptions. You cannot rely on the whole directive. If the whole directive goes away, then the exceptions go away, and you're left with contract. Mm-hmm. So it's you and Ryanair, and you're contracting one-to-one.
L'effetto domino, non c'è la protezione, non ci sono quindi le eccezioni, i contratti che reinstaurano il diritto esclusivo derogano le eccezioni, non sono invalide. Quindi è tutta una questione di contratto.
Yeah, I mean, assuming there's a contract. Which is an issue about which the court didn't decide, I guess, because it's not its business, her business. I don't know how to. You mean?
Okay, we will come back to that because it's the essence of this talk. We can take a step back and think why does Ryanair they don't want price comparison?
This is interesting.
Why do they sue and they say I don't want you to use this? They're supposedly would gain of that because they claim that they're so cheap, that it's cheapest. And if they really are the cheapest, what's the problem of showing it to the world? Would this not increase what we say transparency in this business? An answer is that they're not as cheap and that they want to hide it. And that's the first answer. The second answer is that the Ryanair wants us to use only their site because they want us to see the advertisements, which is a whole market and a lot of money. And a third point there I didn't put in, but I think also exists, is a thing of possession that companies usually show. They want to possess their site, they want to possess their power.
Matter of jealousy.
Yeah, but it's a matter of power, and it has to do with their lawyers, I think. Because they want to see, or to say to their client, I save this for you, this is yours. Nobody can use it except you. So it's a whole set of business and psychological reasons, I think, that Ryanair does not want anybody else to use to the site.
May I just qualify the advertising related part, because part of what they advertise, or maybe the core of what they advertise, are complementary goods.
Yes,
like
insurance.
Hotels, insurance, and cars.
And cars.
And so, I mean, it's not. It's difficult to rule out the possibility that they simply have very low margins on the airplane
Tickets,
fees,
yeah.
on the tickets, while they have reasonable or higher than the average margins on the hotels, for instance, where, for instance, they could have the same margins of booking or whatever.
Right.
So maybe
So they need-
we are eliminating
so they need
their
this,
profit
okay, from
if
economic
people
point of
don't
view.
use their website. So
Okay, it could be, and that was a matter of fair competition, but anyway, we'll see. So what they claim though, because of course they had to give an answer to the court, why do you do that? Is that we need to protect our customers from mistakes. We need to have consistent quality of services and post-sales assistance. They claim that by buying from another provider, you will never learn if the flight has been cancelled or delayed, and then customers will have problems in flying. But in general, as I said, Ryanair has been very active in courts and sues on anything. So what they claim now is that what we want now is contract, of course. They forgot all the arguments about having an original database or a sui generis protected database, and they stress, no, what we need now is just contract. So let's see, can we use contract here? Contract is a right in personam, it's what we want. We have freedom of contract, but this one we have to stress, this contract is a contract of adhesion, where I click I agree, otherwise I don't take the data. So I have to accept all the terms of all the terms. So it's particular contract. It's not like every other contract where you negotiate. You're not going to negotiate with anyone. You just say I accept. That's one problem. The second problem is that Ryanair has this so-called sole source database, which means very important. The only one who has this database is Ryanair. It's not like you're contracting for something that you can buy at the next shop. If you're going to buy a ticket from them, it's only them. So they have the competitive advantage 100% here. And the third thing is that this database is available to the public, and everybody can see the data. This is also important because you see the directive in the recitals. It says the exceptions apply to the databases that are already available to the public. It means you want to show to the public your data, and at the very same moment, you want to take it away from them. You cannot have it both ways. That's what the directive said. So you have exceptions. So one needs the action here. You need the access. Because they have the data, you don't have it, and they are available, but then again, you have to tick, I accept. So what's the result here of the court? What is what I understood of this? I think we use contract to make, again, this is reconstrued, intangible properties at our wish. This is a paradox, what the professor said before. Is there any logic in this result? We have contracts which exclude fair use with copyright works, where unenforceable by law should be unenforceable also when applied to works in the public domain. Another issue is, do we have a contract only because aviation did click yes? Because aviation, of course, to take this data, they did click yes.
May I just clarify one point? I'm not sure that aviation clicked yes to obtain the data. As you said, the data are accessible to everybody. The data are there, and you can scrape them without having your bot clicking yes.
Yeah, they click yes.
Then no. Then I just did it to be sure.
Okay.
So you click yes to buy the ticket. So they did click yes, but to do another action, which is buying the ticket for the customer. So it may be true or not, I don't know, that PA Aviation is bound by a contract, but the contract was accepted in order to be the intermediary in buying the ticket. If you just want to scrape the data, you don't accept any contract formally. Of course, you are.
Are you sure?
I'm sure in the sense that unless you presume that there is a contract which is accepted by the fact of navigating the website and by having a terms and conditions.
I'm talking about clicking. Are you sure that?
No, I did. Yes, 100%. Today.
Yeah, but
I don't know at
the
the time.
application, what they say is that we did, yeah, we accept, but you know, we did click yes, but we did believe the contract. We believe that you're abusing us. We have to take it.
I mean,
That you're pressing me. So okay, I click yes, but I don't mean it.
Tu stai dicendo che sei andato a vederli e che visto che sono lo screen.
Yes,
important.
I agree about the fact that in order to do what they did, PA Aviation had to accept the contract because they did two things, not just one. They scraped the website to recreate the data set, and they sold the ticket. If you want to sell the ticket, you have to accept the contract, because if you don't accept the contract, Ryanair is not going to sell you the ticket. If you read the terms and condition, you cannot use for commercial purposes, blah, blah, blah. And so this is absolutely accurate. So it's true that PA Aviation had to accept the contract. At the same time, if a third party without any interest in selling the tickets want to simply compare the prices, they scrape the website, they don't accept anything, and imprint. Of course, Ryanair will fight this with technical measures, whatever. You can ban the IP address, you can fight on the technical ground. But it's another ground, battleground. So, I mean, in my opinion, it's not completely true that in order to read the data, you have to accept anything. Maybe this is relevant depending on national contract law in order to qualify.
Yeah, exactly. You see, the behavior shows that you accept these terms and conditions. Because you like them.
You can imagine a situation where PA has a subsidiary, PA purchases the ticket, and the scraping is done by the subsidiary, which makes available the scraped data. So in this case, the subsidiary would not have clicked. So this is a possibility. In fact, in this case, they had clicked. In any event, we are talking about, this is an important detail, but still it's a detail. Maybe we should go.
Yeah, we can finish this and then, yeah. So anyway, when you throw it to the national laws, for example, in the UK law, it's mixed as to the validity of these general terms and conditions in a website. The law is not clear as to whether these general terms in a website, they bound you or not. And when what you get is a not clear law, and not one, but all one by one the members of the European Union, not clear, then what's the result about what's going on with the databases? What's the result? And the same is under Dutch contract law. We don't know about the validity, same in Greek, the same in general. But the important thing to me is not what's going to go happen with contracts. The important thing is, can we license a public domain work? Can we license a work whose copyright has ended? For example, I'm making an analogy here. We have a collection of facts, which is not protected by the database. Let's say these telephone listings, okay? And so this is the public domain. This is open data. And we see, if we accommodate us, that when they deal with licensing of public sector information, reuse, they always note, I found out with the for example, that they have to do this because these collections are protected by the sui generis right, which can be held by the state. Otherwise, then it's public information, and there's no good talk about licensing it. For example, if you walk in a public park and there is a note at the entrance, don't enter, but you do. Is it a breach? Did you breach a contract? Did you have a contract with them not to enter, but in a public park? This is the analogy to the real tangible world. And is there a third space then? A space between copyright, enclosed space, and open, free data? Can we have a licensing space, a gray area that would contain users? We have authors of works, we have makers of databases, but is there a third class? We see the word owner of a database everywhere in the text, but from an IP point of view, this makes no sense. But does it make sense in contract law? Can you own data in contracts when you can't expose them in IP? This is, to me, the question. The dangers if you use contract. The terms of the contract should be determined by competition. It's a free market. Should you use your monopoly, example, Ryanair, to this database, to prevent competition? Are you in abuse of a dominant position and with the averages of the court? There is no real contract here with Ryanair users because there is no freedom. A licensing regime may have social and political consequences by causing information inequality. This is a nice phrase of a colleague. Creation of new information depends on exposure to existing information. Commodification of information here raises barriers to an extent that would be socially undesirable. We need a contract theory that gives us boundaries to power. Copyright was born because contract wasn't enough to exclude free riders. Current technology has extinguished this because now you can enclose anything technologically when it comes to information. So let's go back to the history of the database directive. Scholars in the beginning had dreaded, means hated this new, like me, this new terminology, maker. And you're not an author, you're a maker. Substantial investment. You know, we are in copyright about original works of the mind, and we talk about investment, which is unfair competition. The lawful user, not the public. No, it's not author and society. Author and the public is a maker and the lawful user, somebody who uses something. It was wrong in the classic intellectual property sense. It was unfair competition, this database directive. It was masked as intellectual property, and the mask was bad. But even if our wildest dreams, I put myself in these people, have we not dreamt of the case where all this is unnecessary, it's irrelevant, because the whole directive is useless now. It's useless, it's unnecessary, and it's a failure. Because we've seen all this criticism against the directive, and even in its own evaluation by the European Commission, the proposal was to ban it, even if it didn't. Well, this is my conclusion, we've banned it now. But at the entirely opposite direction. It's useless because we've managed to enclose open data with contract. So now you have to tell me what you think.
Thank you, Maria. So this was a pretty weird decision, in fact, an unsettling decision. Maybe we should have a round of comments on this decision. Cristiana, what do you think?
While Maria was talking, I was thinking about when we have contracts and when we do not have them. So this will be my first question, which is linked to what Federico was mentioning. I'm not entirely sure to understand when we have an acceptance by conduct or not by conduct. And then it's also linked to a further question, which is when we are in the public sector, do we really have contract when data are available, or is it a unilateral act of the administrative body? I don't know, I have many basic questions that aren't clear to my mind, so.
We're in the same position.
This does not really help to in the vision of the specific decision.
So we have discussed a lot about public sector information, and in connection with non-transactional licenses. Non-transactional license means that the data are just up there. You don't click anything, you just have the data.
Yeah, and indeed, non-transactional licenses are based on the assumption that to do anything, you have to accept the license, or you just live with the default status created by copyright or related rights law. So non-transactional licenses cannot restrict your freedom, they just expand it. I mean, this is explicit in most open licenses, just to be sure, but it couldn't be otherwise if the data are accessible online. So, I mean, it may look paradoxical, but I'm not surprised by this decision. Even if I'm a supporter of open data, I'm also a supporter of freedom of contract. Assuming I got right this issue of acceptance of a contract, I don't see the paradox. I should read, of course, the actual wording of the court, but if assuming there's no acceptance, it's okay to scrape the website of Ryanair and recreate the database, and I'm happy. So, of course, also with respect to selling public domain books, here we could disagree in the sense that I would like to see a scenario in which there's no, let's say, consideration for a contract in which you give me a scanned copy of a public domain book and I give you some money, and then I'm bound by the contract to use this just for myself and for non-commercial purposes, or for my commercial purposes, and I'm prevented from making it available to other people, and so on. The activist, which is in me, would like the public domain to be so powerful as to, I mean, supersede contract law in this way. But I don't see a paradox in the fact that if access, for instance, is conditioned upon the acceptance of a certain contract, then you are bound by the contract. But I completely agree with Professor Bottis about the fact that you cannot have both words. So you cannot show your data to the public without a registration, without acceptance, using the normal functioning of the web. You just go there and you see what you want to see, and at the same time pretend to use contract to protect this data. So if Ryanair wanted to prevent people from scraping the data, in general, I would be surprised. Well, I would not be surprised because Ryanair would try to go along this road, but I think they would fail in front of the Court of Justice. If somebody accepted a contract for another purpose, and this contract also implies that they should not use the information they scraped for a certain purpose, I don't see a paradox. I just see a contractual problem. So I mean, this is just an additional comment with respect to what I said beforehand.
We summarize what Cristiana said. Is it a contract or is it a unilateral license? If it is a unilateral license, then a unilateral license has a meaning only to the extent there is some IP protection. If there is no IP protection, then it is not that by not complying with the terms you go back to the default regime, you go back to the public domain. On the other hand, contractual freedom is valued, but then this is moving from Cristiana to Federico. The question there is contract, formalities of contract. This click has been there, but for other purposes. Has it any impact? Then, again, summarizing what Federico was saying, Otherwise, if there is not such a click, then we don't reasonably see a contract by the fact itself of scraping and reusing. There is no meeting of the minds. And I would turn maybe to Miriam, asking, in terms of European consumer law, there is the Unfair Contracts Directive. In Italy, this is any other lawyer out here, yes, the two students. In Italy, we have the provisions of the civil code, and Avvocato Fascelli would also be involved, of course. So, in terms of limiting the possibility of having a contract here, what would the European Unfair Contracts Directive say in connection with this? Anything at all? What would Article 1341 Italian Civil Code say? And when you're thinking about it, to have a contract, you have to have a consideration. There must be.
Yes.
This is what.
Yeah, this is the main problem.
So, what are you getting by agreeing? You are the user, not lawful, because we don't know yet whether he or she or it is the lawful user or not. We have a user. He is saying yes, but there is a meeting of minds, but about what? What is what we call in Italy causa? What is the object of the consideration? Causa. So what is, and the big point is what Maria was making. If there is not a causa, then maybe it has the form but not the substance of the contract. There is also another point which Federico was making. This is all based on the fact that there is no technical protection measure. If there is some kind of cryptographic protection and you cannot access, then it's different. Then it's different because you have to go through the restriction of having to log in first. And let me say this is something which has been discussed 20 years ago. There is a, I don't remember whether it is a regulation or a directive, which is called 9894, which was before 94. This is before the internet, but the beginning of the internet. And this directive said that if you access material or content which is under cryptography, you have to respect the terms and conditions. And immediately Thomas Heider, who is a very good scholar, said, yes, but if the stuff is in the public domain, you accept to be restricted on something which is free. So Thomas Heider was saying that even if there is technical protection measures, there would be a functional defect in the contract. So you are agreeing not to do something which you would be able to do anyhow because it is in the public domain. So this is even more so if it's not protected by technical protection measures. Miriam, the Unfair Contract Directive, to your understanding, is saying something in this connection like a consumer wanting a user, the user who wants to know information about air flights, prices, and so on, going up the website, accepting restrictions. Is there anything in the Unfair Contracts Directive which might, well, we don't know. We are going, in Article 1341 of the Civil Code, which is important because Article 1341 requires the double click at the minimum. Actually, it requires a double signature. So the first problem is the signature equivalent to a click? Is it? We don't know. We have cases which say yes, but we don't have cases saying that double click is complying with 1341, which is a very important issue. So we have a whole range of questions here around the table.
And probably you have to see this through all these laws, because every member state has its own law of consumer protection.
Yes, but this is my more benevolent reading of this case. In my opinion, the Court of Justice, and let me read exactly the lines, is saying something which is not so technically bad as it would appear in the rendition. This is paragraph 45, and let me, before reading it, give you my understanding of this paragraph 45. The European Court of Justice is saying, we guys deal with European law. So when we have a database which is copyright protected, we are talking about European law. When we have a database which is protected by a sui generis right, we are talking about European law. And of course, there are also limitations and exceptions and contracts restricting these. And we're still in European law because the starting point is European law. But if we don't have a database which is protected, we are no longer talking about European law. Actually, the European Court of Justice and European Community law does not deal with contract law or property law unless you have something specific like unfair contracts directive. Property law is even a bigger problem. Nay, European law deal with property as such without connection with a specific mandate. There is a restricted competence regime in the European Union. So the European Court of Justice says we have to confine ourselves to European law. And yes, we look at contracts, but if and to the extent European law is involved, if there is no IP protectable databases, we stop. We don't speak. Having regard to, this is paragraph 45, having regard to all of the foregoing considerations, the answer to the question referred is that Directive 96.9 must be interpreted as meaning that it is not applicable to the database which is not protected either by copyright or by the sui generis right under the directive, so that Articles 6.1, 8, and 15, which are the provisions concerning exceptions, limitations, and contracts, do not preclude the author of such a database from laying down contractual limitations on its use by third parties. European law does not preclude that without prejudice. For me, this is essential to the applicable national law. So they say, actually, this is a matter of national law. Maybe it's terrible what is done because there is a contractual restriction on something which is not a contract, bilateral license, Christiana. Maybe there has not even been a technical protection measure so that there is no meeting of the minds, Federico. Then it may be terrible also because it is reappropriating, commoditizing what is in public domain, Maria. But if all this is terrible, it is something which we at the European level have not dealt with, so you have to say that it is against Italian law. In my opinion, it is against Italian law, against Greek law, and we have to start a big work, and if we have dishomogeneity or disharmonization, maybe it's time to have another regulation concerning this.
On top of that, I love the way I don't agree, but I love the way you express it. You see, Michael, I am again paragraph 4. I don't like, first of all, because no, this is not mine. You deal with that. No, that's not. To me, it's not correct. You're going to interpret a directive and tell us whether there's something left for the public domain. If there's something, if this is a public data open data, I want you to tell me, because you deal with EU law and the directive carved spaces and said this is protected and this is public. the interpretation allows this. They could do it, but they did not want to do it, to me. Part 45. So that the directive does not, this database is not original, not knowledge, so the directive doesn't apply. So this does not preclude the author of such a database from laying down contractual limitation. So the author of Ryanair database can use contract, yes?
Without prejudice.
Without prejudice, but they use the word author. They use the word author. So the word author means that there's something there to be perhaps protected. And they also use the very word database, which is of course, it's a sign now that you deal with something approach with database directly. And without prejudice to the national law. So they sort of say, well, let the national courts resolve this. But they didn't take the brave, let's say, step. This is my own interpretation. I'm a very well giver. To say that, look, this is free. This is public data, this is open data. Anyone can use Ryanair data because it's public available, because there's no offer, there's no substantial, there's nothing there. There's nothing. It's yours, you can use it. In effect, this was the result of the 2004 decision in British Conservation Board. I think this was the result that we got, that it's not, this is not that, so it's free. They didn't take this little step forward. So you can very much say, and most commentators say exactly your interpretation of that, it's pure logic. This doesn't apply, this doesn't apply, so contract, national courts. But in the other way, I would very much have liked them to say, open data, it's free, and end it there. I think it would be nice if they could have done so.
But European law tells you what is protected. What is not protected is not European law. What is not protected is something which immediately takes us to other regimes. Like I have a painting, I own a painting. There is no copyright because the author of the painting died more than 70 years ago. So there is no copyright protection anymore. Except that first possibility, this is locked in my house. The fact that there is no copyright enables Christiana to come and nose into my house without my permission? Probably not. Am I restricting European law on IP by denying her access to something which is not copyright protected? Probably this has nothing to do with European law. Now, the different question, which is more like the park you had, the same painting is not in my house. So there is no technical protection measure like a door and a key to enter. It is in a field, which is my field, but it is open for everybody to get into. So there is no physical barrier. But still, Christiana is coming in and I tell her, Christiana, please don't. This is my field. So if you enter it, you trespass. And she tells me, well, it's not copyright protected, so I want to have access. And I tell her, I'm not talking to you about copyright and about IP protection. I'm telling you that the field is open. But if you cross that line, you are a trespasser, so I'm calling the police. Now, this is a matter of European law or is it a matter of Italian law? In my opinion, it's a matter of solely Italian law. And the fact that in the end it is public domain, which is not accessible, is something which for the moment we have to accept. And this is one of the reasons we, even at WIPO, we started to tell them, we are dealing with intellectual property. But the time has come to talk about the public domain and access to the public domain. If we have,
Oh, they love that.
yes, they love that, yes. And they're doing it. So if it's a mistake, we have contributed to it. The idea is that in some ways to say that IP is the positive, public domain is the negative, and you rule only on the positive and not on the negative, sometimes is leaving open issues like this one. If something is in the public domain, is there an entitlement of people to access it? This is the access to knowledge movement and so on and so on. And maybe this is a balancing which would be not only national law, but international conventions and European law. The way it is, I see it as a mostly national law issue, and I'm persuaded that the contractual provisions by Ryanair would be invalid under many legal systems, including ours. So I'm not sure that this is what is called sometimes as a Pyrrhic victory. You know, we're talking about
They're so happy, yeah, Pyrrhic, yeah. But they're very happy on the decision, right? You know, has a front page in the side like, we're so good.
they don't understand. This is Michael Leary all over. Michael Leary is saying, we don't check even people who don't have passport or identity cards. For instance, a card issued by their employer is no good. We want that. They're losing customers. So they like to be Michael Leary. He is smart because he gets so much advertising for these battles that he's making all the time. Somebody has said this is his free advertising because he is nasty. He's tough and nasty. So he's always in the headlines in newspapers, and everybody sees the headline, Ryanair is tough, but they're cheap. And of course he likes the second part. And they're cheap because they're tough. So maybe the really strange thing is that we don't have the Attorney General here. This is totally uncharacteristic. The Attorney General is dispensed with in one case, when this is a case which has already been decided by the Court of Justice, so that there is no point in having again trouble the Attorney General. Here, it's totally novel. It is at minimum strange as a case.
Do you have an explanation or no?
I think there was some embarrassment in the Court of Justice, because I'm not telling you, Maria, that I find that this is a totally normal decision, which is not paradoxical, it's logical. No, I'm telling you that it is troubling, because what they're saying is no protection on the one side, no protection on the other side. Therefore, contractual restrictions go very well. But there is something which is funny in this reasoning. So it is in some way embarrassing.
Or maybe he disagreed. Maybe he would give an opinion that they wouldn't like.
Well, we may have a conspiracy theory and say, who would have been the Attorney General if the precedence of what Bottis is saying would have gone to the opposite direction? So it's better not to get him involved in the process. By the way, I didn't see who are the judges. Sometimes you have to look at the judges. The Advocate General was involved.
So you know something.
And the president of this is a second chamber. This is technical legal stuff. This is the Court of Justice, but it is the second chamber. So it is a decision which is taken by a chamber. It's not by the plenary session, and it's not by the grand session. It is only 1, 2, 3, 4, and 5 judges only. Only means there are a lot, but compared to the 17 judges of the grand decision, it's Silva La Puerta doesn't mean anything to me. So I am not able to. It is puzzling. It is puzzling.
Well, let's see. Let's see what happens.
Well, I think that it's a good case to comment. It is not so new because.
January.
Yes, it's January. Did it escape your attention? Did it escape my attention as well? Yeah, no, thank you.
Well, the way they write it is like they want to escape attention. Right?
Yeah. And also the European Copyright Society is always very vocal and feel that the democratic dimension, the access to knowledge is restricted, the openness, transparency. But I don't know that the European Copyright Society has said anything about it.
I have no idea, but I have an update which reduces the value of what I said beforehand in terms of effects. In the sense, discussing over Twitter, we verified, but indeed, I was using to check the flights, the first result from Google, which is indeed a kind of broker of Ryanair flights. So somebody doing like BA aviation. So if you go straight through the Ryanair website, there's something which is something to be assessed by national law. That is, they say that by clicking find flight, you accept the contract. So they are trying to bind the acceptance.
So your previous was through an intermediary who had already clicked.
Yeah. If I scrape the intermediary, I accept no contract, and I'm using data in the public domain.
But they have a contract.
But they have a contract. So indeed,
the name of plus juris transfer potes quamicce habet.
Yeah, but I don't want the transfer of rights. I just want the transfer of data because it's in the public domain. Anyway,
if the broker intermediary has not acquired right on the data, you, as successor in title, are in the same position as the intermediary. You cannot have more than he has.
Yeah, but I don't want rights in this data. I just want the data because there are no rights in this data as a contract. Do I inherit the contract as well?
No, but
I mean,
the maxim is very precise because Roman was nemo plus juris transfer potes quamicce habet plus juris. Juris means a lot of things. Contracts, rights, but also de facto possessions.
Yeah. I mean, transfer mean. Yeah, but what I don't get is how could I be aware, for instance, of the fact that data which are in the public domain by their nature, according to what the court said, and which are online accessible, could have arrived there, meaning online, through a path which may or not be lawful.
This is a matter of mind, of subjective intent. If you're not aware, you're not going to pay damages because there is neither intent nor negligence. So you don't pay them. But the fact remains that you're unlawfully handling the data. So you're not a lawful user. So this is acting on the level of paying damages. If you don't have mens rea, if you don't have intent or negligence, then you could not know it, you're innocent. Okay, innocence don't pay. But are the data lawful because they got to an intermediary? If they were not clean at the beginning, it is not that they come clean in your hands.
So at the end of the day, you essentially agree with the court in this case.
No, I'm telling you that Miriam will help me to look at the unfair contracts directive at some point. Bianca and Antonio will help me by looking at Article 1341, and there is this important issue also for your dissertation, Bianca. Is it sufficient to have 2 clicks to comply with Article 1341? Or is it necessary that you have 2 signatures, and maybe also digital signatures, which are not clicks? And we have issues of consideration, we have issues also of constitutional value of freedom of access to public domain, and we have a lot of things to look at from the national perspective. The Court of Justice simply said it is not our matter, and they were a little bit clumsy, but I don't think that it is so terribly wrong. As
It was.
yeah,
We'll see what happens.
we see. Yes, we see also what are there interpretations of this decision in European intellectual property?
I didn't find.
Yeah. Maybe it's
I tried to read everything that was there. I mean, everything I could find. There were maybe people who were very much against, but not in a big article saying this.
Did the National Court take its final decision?
No, it's too early.
Yeah.
It's too early. But you know, for
I tell you, the National Court is in Amsterdam.
Yeah, indeed.
So in Amsterdam, they will probably try to follow my reasoning. They're very liberal in the Netherlands. They will try to find if there is a way to say, yes, okay, it's not European law. But, you know, we Dutch people have other remedies. So there is no consideration, this restriction is unconstitutional.
they would result on contract.
Yeah, yeah.
Yeah, I like the way the first courts resolved it, or the first instance in court.
Yes,
I love that. So
even the second was
it
even
would be very
stronger.
nice if we would stay there and not even go so far and resolve it there. But
how
again,
how could have the European Court decided differently? I mean, how could they say that an exception or limitation to a certain right applies in cases where there's no such a right?
No, they
I
could
mean,
have said,
in a way,
they could have said that, and this is, I'm trying to interpret Maria, and this is the part in which I feel a lot of sympathy, and maybe she is right after all. The European Court might have said, if we have decided that such restrictions will limit the limitations and exceptions, are null and void, even if there is the IP right, it's a matter for European law to say that a fortiori, a fortiori, they're invalid if there is no such protection. So by necessary implication. And they have a doctrine, which is very important, which is the effect utile. The purpose of this provision would not be served by having valid contractual provisions, in spite of the fact that the data set, they should not have used the word database, they should have said data set, is not protected. So, a fortiori, to maintain the effect utile of the directive, we have to rule that they're invalid.
so
This
they
is
would
what
do
we would
it.
have
Yeah,
liked.
exactly.
They did not do that. They did
You
exactly
expressed it
that.
so beautifully. I feel so.
I was not sitting on the bench. I don't know why.
Yeah, well, it's exactly what I would like to have said. You said it,
Yeah.
but I expressed it in my way. Yeah, I would love it
I
if
was-
they
it was
would do that.
interpreted,
You know,
yeah.
yeah, okay, well, yeah, that's what I would like them to have said.
Ok, avvocato, ci dice qualcosa?
Yes, well, it's a very interesting matter. In my job, I see this as a part of the war between competitors for client database, and which was an insurance company had a part in this war. And then it is a war that is fought not between lambs, but between sharks, not for civil rights, but for money. So Ionian takes a decision. The two points of the decision, I think them not particularly disputable.
Okay,
Debatable. Because if there is a protection under the EU directive for a database, the owner of the database can expect a protection under the database. If the data are open, so we have a contract, if the contract is valid and stands for law and under a law point of view and under an economic point of view, why not to have a contract? In any case, we have the shadows of our competition antitrust authority, which must say whether the competition is unfair. So, if the competition is fair, I love both contracts if we can have a lawful contract, and I welcome the protection of the
So Avvocato Fascella is more on my conservative interpretation side. of
But he's your
it.
friend, that's why. He's your friend.
Okay. Well, Maria, I think that this time this was a discussion of a case, so we have been quicker than usual. Do we have other comments to make, Antonio?
No, I feel that the real problem is not probably the IP law or contract law, but the finding a balance between the different interests on the field. So Ryanair's interest about his own side, the interest of the PA aviator in doing his own business. So I think that it's always difficult to find this balance, even more on the internet.
But Antonio, you'll have a chance to read or reread this decision. It has a very, very interesting and debatable point, which says that the balancing is not required in this case. Paragraph 40. As Ryanair and the European Commission have stated, the directive sets out to achieve a balance between the rights of the person and the right of the user. Then it goes on to say, yes, but balancing, you balance when there is IP protection. If there is no IP protection,
Nothing.
no balancing. Well, this is
It's a simple
really,
paradox of the case.
this is really very logical, but makes you jump a little bit. No IP protection, but we can say then public domain and access.
And that's it.
And they say, no, you can, the owner, the de facto owner of this data can do anything he or she likes. No balancing implied. Well,
He or she can, more than anything he or she likes. I mean, meaning that really, then it's a matter of what you can enforce, technically and contractually.
Exceptions don't come out of the blue. They are established because, for example, if they are mandatory exception, because there are fundamental rights or policy reasons. So even if there is no need to balance with IP rights, so these other fundamental rights should
This is Miriam, she has a very good point. I think balancing limitation exceptions don't come out of the blue. It is not that the trademark lawmaker has created, the copyright lawmaker created. No, they come out of freedom of expression, competition. So maybe if you don't even have these in black letters law, are implied in the legal system. So we might say that there are explicit limitations and exceptions when there is copyright and exclusive right. And then equivalent, possibly broader limitations exceptions when there is no black letter.
This is a theory I may like, but still, you could also say that the limitation and exception mitigate the rights that you created erga omnes through the intellectual property right. So if there's no right to be action against everyone in the world, then you don't need it.
I would say, but you cannot create a right erga omnes by contract. And so the limitation to this is that it is.
And indeed here, the defense against this, in my opinion, is that you cannot create a contract by a stupid notice used. Meaning, you click on find flights, yet there's a small notice in gray down there saying, by clicking find the flights, you also accept something which is in another page, 20 pages long, describing the terms and conditions. Then, I mean, I would use contract law to fight against contracts.
So we all agree on one point,
Yeah.
and we finish with that. Ryanair should, in the end, lose.
Of course. Of course.
We are divided between those who would say that they should lose on the grounds of European law and IP law and the balancing between IP and public domain. And those who say that they should lose on grounds of contract law and national law. But the outcome, in our opinion, should be the same. And if I know the Amsterdam court, they will lose.
That's good.
Okay, grazie.
Thank you. Thank you.
And it was a small group, but it was a like to discuss.
It's a great view, a great view. Thank you very much.
Yeah.